Good evening, everyone. I'm Daniel Benjamin, and I am the president of the American Academy in Berlin, and I'm delighted to welcome you to tonight's lecture, The Supreme Court versus the Administrative State, which will be delivered by Judge David Tatel, who is this semester's Lloyd Cutler Distinguished Visitor. This is a really wonderful occasion, and it's a great subject to be discussing in the run-up to an election that will have, I think, a fateful impact on exactly this question. So I'm enormously grateful that Judge Tatel can be with us here this week to discuss this. So first, a bit of background on this visitorship. The Lloyd Cutler Distinguished Visitorship was initiated in 2008, honors the legacy of one of the Academy's very first trustees, one of the founding trustees, Lloyd Cutler. It's hard to imagine that there are people who don't know who Lloyd Cutler was, but for those of you who don't, he was one of Washington, D.C.'s most prominent attorneys. He was the co-founder of Wilmer, Cutler, and Pickering, today known as WilmerHale. He was an advisor to many presidents and served as White House counsel for President Jimmy Carter and for President Bill Clinton. And he also served in the administrations of Presidents Johnson, Reagan, and George W. Bush. And wasn't that a different day when you could imagine someone being in all those administrations of different parties? Yes, might one pause on that thought. When Cutler passed away in 2005, The Atlantic called him the last super lawyer. Anyway, it's in this spirit and in recognition of his extraordinary record that the Lloyd Cutler Distinguished Visitorship at the Academy brings leading U.S. legal scholars and practitioners of the highest renown to Berlin for in-depth exchange with German colleagues, counterparts, and the interested public. Former Lloyd Cutler distinguished visitors include Roberta Cooper Ramos, Stephen Breyer, Linda Greenhouse, Harold Coe, and Grania de Burke, among many others. And I'm particularly delighted that Martin Seifert of WilmerHale here in Berlin is here tonight. So let me turn to our speaker. Judge David Tatel served on the United States Court of Appeals for the District of Columbia from 1994 to 2023, and he is just very recently retired, so you've caught him at a good moment when everything is fresh. As many of you will know, because of the special nature of its docket, the U.S. Court of Appeals for the D.C. Circuit is generally considered the second highest court in the land. In his time on the bench, Judge Tatel heard cases on one landmark issue after another, from the rights of prisoners at Guantanamo to the future of the internet, and from the Voting Rights Act to the fundamental ability of our executive agencies to keep America's air clean. He established a record as one of the most influential jurists in the nation. Steve Vladek, a leading constitutional law scholar at the University of Texas and a keen observer of the U.S. judiciary, observed, "For a judge who can't see, he sees everything. Not just what is going on in the case before him, but how it matters in the future." And he added, "It's hard to think of a judge who is more highly respected on the federal appellate bench, even by those who disagree with him." Early in his career, David Tatel was also the founding director of the Chicago Lawyers Committee for Civil Rights under the law, and then he was director of the National Lawyers Committee. During the administration of Jimmy Carter, he headed the Office of Civil Rights of the U.S. Department of Health, Education, and Welfare, where he did vitally important litigation to, among other things, make America's schools provide equal opportunity regardless of race. He founded and led the education practice at the firm of Hogan and Hartson, now Hogan Lovells. I don't know why law firms can't hold on to their names. They keep changing. Anyway, he is now a senior counsel at that firm. He is a member of the American Philosophical Society and the American Academy of Arts and Sciences. And let me just add a final few relevant facts. David Tatel has run 3 marathons and spent many, many years of his life skiing. He's done his share of rock climbing and camping, and more importantly, and most importantly, he and his wife, Edie, I hope I get the numbers right, who we're delighted is here tonight, have 4 children, 8 grandchildren, and 1 great-grandchild. Did I get the numbers right? Sometimes I surprise myself. And finally, one of the things that I hope we'll get to a little later is that David has a book coming out in June entitled Vision, a Memoir of Blindness and Justice. I was fortunate enough to extract a copy of The Galleys from Judge Tatel, and I can't recommend it more highly. You may have seen these postcards. There's a very useful QR code on the back. Order yours as soon as possible. Let me just say a word or two about the structure of the evening. David's talk will last about 35 minutes and will be followed by a discussion and Q&A. If you're following on Zoom, please enter your questions in the Q&A, not in the chat. I am correct that we will have that kind of Q&A, right? I'm asking my staff. They'll let me know if I'm wrong. Anyway, it is absolutely an honor and a pleasure to welcome David Tatel to the American Academy.
Thank you, Dan. It's a real pleasure to be here. I've known quite a few people who have spoken here before, and it's an honor to be invited to be here. I was one of those people who knew Lloyd Cutler. It's a special honor for me to speak here because I'm such an admirer of Lloyd. Dan's right that Lloyd Cutler was a super lawyer, but he was also a super person. Dan mentioned that I was the director of the Lawyers Committee. Well, Lloyd hired me for that job in 1974, and 20 years later, Lloyd was counsel to President Clinton when a vacancy on the D.C. Circuit emerged because the president had appointed Ruth Ginsburg to the Supreme Court, and I've always been convinced that Bill Clinton picked me because Lloyd told him to. And in the middle of those 20 years, Lloyd and I worked on many civil rights cases together, including a major civil rights case lawsuit on behalf of the NAACP that ended up in the Supreme Court and is one of the most important First Amendment civil rights cases. And I tell that story in a chapter in my book called Too Beautiful to Burn. What I have tonight is an abbreviated, edited version of Chapter 17 of my book, which is called The Future of the Climate. I've added a new beginning because I thought it would help for tonight. There are two things you need to know just as background. One is the U.S. Court of Appeals for the D.C. Circuit sits right below the Supreme Court. And it hears, most of its cases come from administrative agencies, including for purposes of tonight, the Environmental Protection Agency. And its decisions are appealable directly to the Supreme Court. And although there's 11 judges on the court, we hear our cases, I have to remember to speak in the past tense here. We heard cases in randomly selected panels of 3. So that's number one. Number two, you'll hear quite a bit about judicial restraint. That's what my book's about, at least the last third. Judicial restraint are the judge-made rules that are designed to ensure that the unelected federal courts don't intrude into the proper roles of the 2 elected branches of government. I have a lot to say about that. Okay, so as I said, this is an abbreviated version of Chapter 17. Unless you've just arrived from Mars, you know that the world is facing several major challenges: climate change, global pandemics, artificial intelligence, just to name a few. You're also probably aware that finding solutions to these problems is a source of great political controversy in the United States. What you may not know is that a meta battle is playing out in the U.S. courts about whether and how the federal government can address such issues. It's a battle over the so-called administrative state and the role of government agencies. That may sound like arcane bureaucratic intrigue, and okay, maybe it is, but it matters. Agencies tasked with implementing congressional laws have played a crucial role in America's democracy since the nation's founding, and especially since the 1930s. So any debate about agency power is really a debate about government power, and that debate is at an inflection point. For decades, the conservative legal movement has laid the groundwork to weaken federal agencies, and those efforts are starting to pay dividends in the Supreme Court, big dividends. But first, some background. As I'm sure you know, the United States government has three branches: legislative, executive, and judicial. Congress makes the laws, the president enforces the laws, and the courts adjudicate whether someone has broken those laws. The separation of powers, together with a government of limited authority and a Bill of Rights, protects our most fundamental liberties. This all sounds good in theory, but it's a tall order in practice. As the country has grown, government has become more complicated. Congress is busier, problems are bigger, and figuring out how to address them takes more and more specialized knowledge. Enter federal agencies, authorized to implement congressional goals and staffed by subject matter experts. Agencies are the workhorses of the federal government. Almost 450 agencies issue some 3,500 regulations every year. I want to focus this evening on just one of those agencies, the Environmental Protection Agency, the EPA for short. The story starts with the Clean Air Act, a landmark federal law that saved millions of lives in the half-century since its enactment. In designing the statute, Congress recognized that air pollution is a dynamic problem. New harmful pollutants will continue to be identified. The science of pollution will continue to improve, and industry will continue to find ways around whatever rules Congress puts in place. So Congress crafted a dynamic solution. It set out the basic legal framework for controlling air pollution, but left the details to a specialized federal agency, the EPA. There are good reasons why Congress wanted the EPA to fine-tune and continually update air pollution regulations. Like other federal agencies, EPA is part of the executive branch. Led by the president, the executive branch is quicker and more flexible than Congress. Whereas members of Congress, like judges, are generalists, federal agencies are staffed with subject matter experts who know virtually everything there is to know about the areas they regulate. Even the most scientifically minded senator will know next to nothing about how quickly heavy-duty trucks emit nitrogen oxide and other pollutants, the health risks those emissions pose to humans, and how those emissions can be curbed through cost-effective measures. An EPA scientist, by contrast, can devote her entire career to the study of nitrogen oxide. Down the hall, a different EPA scientist can work to identify new pollutants. His neighbor can stay abreast of the latest pollution mitigation technologies in the trucking industry, and across the way, a medical expert can study the health effects of various pollutants, including on sensitive groups like people with asthma. Working together and with input from the public, these experts devise and continually update regulatory standards that keep our air clean and our sky and our bodies healthy. That's the Clean Air Act at work, exactly as Congress intended. By contrast, in reviewing EPA emission standards, the role of the courts is limited. Judges, unlike agency officials, are not scientists or subject matter experts. So when courts decide a Clean Air Act case, or any case involving an agency for that matter, their job is not to decide whether the rule the agency picked was the one it would have chosen themselves. Instead, a statute called the Administrative Procedures Act requires courts to respect an agency's scientific judgment unless it acts arbitrarily and capriciously. That's administrative law speak for totally irrationally. And under a doctrine called Chevron, named for a Supreme Court decision, judges must also respect an agency's reasonable interpretation of the statute it administers. For example, if Congress tells EPA to regulate areas seriously affected by auto spills, courts must defer both to EPA's scientific judgment about which areas have been affected, unless that judgment is arbitrary and capricious, as well as to its interpretive judgment about what seriously affected actually means, unless that interpretation is unreasonable. Arbitrary and capricious review and Chevron deference keep unelected judges from second-guessing agency decision-making. Consistent with those principles, so long as an agency considers the relevant factors, reaches a rational conclusion, and interprets the governing law reasonably, the agency's decision, not a court's, must carry the day. By deferring to agencies, judges respect Congress's judgment to delegate authority and avoid imposing their personal policy preferences. My first major environmental case, American Trucking against EPA, came 5 years into my tenure on the court. At first, American Trucking looked like the sort of case we see every day. EPA had set a new emissions standard. Someone wasn't happy about it, and we had to decide whether the standard the agency had chosen was arbitrary and capricious. The emission standard at issue was for a pollutant called PM 2.5. If you've never heard of PM, and frankly, aren't sure whether you're up to it or even interested in finding out, then you'll understand how I first felt when I opened up the case file. But bear with me, it's both less complicated and far more interesting than it sounds. PM stands for particulate matter, which refers not to one specific chemical, but to any fine particles or liquid droplets of a certain size. Over time, EPA has made its PM regulations both more specific and more stringent, reflecting the agency's evolving understanding of how these tiny particles work and the dangers they pose. For decades, EPA has regulated PM 10. That's particulate matter smaller than 10 microns in diameter. This time, EPA singled out PM 2.5, particulate matter smaller than 25 microns in diameter, for especially strict regulation. A human hair is approximately 75 microns wide. So 2.5 microns is very, very small. And as EPA scientists recognize, the smaller the particle, the bigger the problem. Unlike larger particulate matter, PM 2.5 can travel deep into the respiratory tract and even into the bloodstream, causing serious and lasting harm. Ever wonder why health officials suggest staying inside when there's wildfire smoke in the area? Now you know. Wildfire smoke contains PM 2.5. Industry was none too pleased about EPA's new PM 2.5 standard. Smoke containing PM 2.5 is a byproduct of many industrial processes, and cutting back those emissions can be difficult and expensive. So industry groups joined forces to challenge EPA's new regulation. The American Trucking Association led the charge, with support from other well-funded groups who make it their business to oppose regulation that chip away at corporate profits. The challengers argued that EPA was required to treat PM 2.5 as a brand new pollutant, even though it had long been covered by EPA's regulation of PM 10. More broadly, EPA, the challengers, claimed that EPA had acted arbitrarily and capriciously in setting the standard. Okay, so the science may have been complex, but the arbitrary and capricious standard made my job simple. All PM 2.5 is bad PM 2.5, and there's no level at which PM 2.5 emissions are totally safe. Whether I thought the PM 2.5 standard should have been a bit higher or a bit lower was beside the point. As a judge, the only question I had to answer was whether EPA had acted arbitrarily and capriciously. Agree or disagree with EPA's ultimate conclusion about PM 2.5, I saw nothing arbitrary and capricious about how it got there. The agency had considered all relevant evidence and reached a logical conclusion. Case closed, at least for me. Not so for my two colleagues on the panel. Instead of applying the arbitrary and capricious standard, they latched onto an argument that threatened to unravel the entire modern regulatory state. That argument was an idea called the non-delegation doctrine. You won't see those words anywhere in the Constitution, but alarmed at the pace of New Deal legislation, the 1935 Supreme Court contrived the doctrine in order to overturn regulations it felt interfered with the free market. The basic idea was that the Constitution implicitly prohibits Congress, quote, from abdicating its legislative function, that is, its power to make governing law, by delegating those functions to executive branch agencies. Any statute that does delegate legislative power, the court declared, is unconstitutional, and all regulations promulgated pursuant to that statute are void. In theory, the non-delegation doctrine is about preserving Congress's power and about preserving Congress's power to legislate and making sure that executive branch agencies don't take that power for themselves. In practice, though, non-delegation is all about the Supreme Court's own power, because by invoking the doctrine, the court disregards Congress's legislative choice in favor of its own. Thankfully, it didn't take long for the Supreme Court to see the problem with its made-up doctrine, which in its initial form seemed to preclude meaningful agency involvement in all agency policymaking. In later cases, the court clarified that Congress may delegate decision-making authority to federal agencies so long as it sets out some, quote, intelligible principle to guide them. Since then, the court has consistently upheld statutes delegating substantial authority to agencies. An intelligible principle isn't a very high bar, and it's one Congress can easily satisfy while still leaving agencies considerable discretion to exercise their expert judgment. My colleagues, however, zeroed in on the discredited non-delegation doctrine and all but ignored the cases that followed. They also ignored that Congress, in designing the Clean Air Act, gave EPA a clear mandate to set emission standards at the level, quote, and this is a quote from the statute, requisite to protect the public health with an adequate margin of safety. In implementing that mandate, reasonable regulators might disagree about which measures are requisite to protect the public health and what an adequate margin of safety means. But the principle the Clean Air Act articulated was certainly intelligible, the only requirement under the post-New Deal case law. For that reason, I didn't see any non-delegation problem in the statute. But I couldn't convince my colleagues to see it that way. They thought Congress had given EPA too much power, and ruled that EPA's exercise of that power in adopting the PM 2.5 standard was unlawful under the non-delegation doctrine. I had no choice but to dissent. The implications of the majority's position were staggering. Its articulation of the non-delegation doctrine called into question not only EPA's authority to regulate air pollution, but also the authority of every other agency whose work is crucial to keeping people safe and society functioning. At the end of the day, I didn't see how Congress could have spoken more clearly, while still giving EPA the flexibility necessary to regulate PM2. Did my colleagues really think that Congress should be in the business of evaluating changing scientific evidence and revising emission standards? I doubt that's the result they wanted. Industry groups and the lawyers who serve them are well aware that Congress lacks the specific skills and, frankly, the attention span to regulate on in complex spaces, the environment chief among them. They also understand that because of hyper-gerrymandering, the Senate filibuster, and money, Congress is largely ineffective or, worse, most responsive to special interests, not the public interest. So as a practical matter, if Congress can't delegate to the regulatory details to administrative agencies, it won't be able to regulate in those spaces at all. That's why shrewd legal conservatives serving corporate interests have long recognized that resurrecting the New Deal non-delegation doctrine might be the key to radical shift in American government as we know it. President Trump's White House counsel once remarked that the greatest threat to the rule of law is the ever-expanding administrative state. His proposed response, a strong judiciary, by which he meant judges unchecked by principles of judicial restraint and armed with words like non-delegation. Fortunately, the Supreme Court, in this case at least, was applying the law, not making policy. It unanimously reversed the mischief-making of my colleagues. Justice Antonin Scalia wrote for the court, liberally adopting the reasoning of my dissent. This is what he wrote. We have almost never felt qualified to second-guess Congress regarding the permissible degree of policy judgment that can be left to those executing or applying the law. And the Clean Air Act's delegation to the EPA, he concluded, fell well within the outer limits of the court's non-delegation precedents. 4 years later, in 2005, the panel assignment lottery landed me my next Clean Air Act case. This one was called Massachusetts versus EPA. The novelist and lawyer Scott Turow called it the most important environmental law case in history. The question was whether the Clean Air Act gave EPA authority to regulate greenhouse gases, chemicals like carbon dioxide that collect in the atmosphere, trap heat, and change the Earth's climate. It might seem obvious that greenhouse gases are air pollutants that EPA should be regulating under the Clean Air Act, but at the time, it was anything but. George W. Bush was president, and his EPA insisted that it was powerless to regulate greenhouse gases because they're not air pollutants at all. According to the EPA, Congress had smog, not climate change, in mind when it passed the Clean Air Act. Plus, because cars are the #1 emitters of greenhouse gases, EPA thought the Department of Transportation should sort things out. With the future of the planet on the line, my court again dropped the ball, and I was forced to dissent. Again, the Supreme Court agreed with me, but this time the vote was much closer than it was in American Trucking. Justice Stevens wrote for a narrow 5-justice majority. His opinion, not so accidentally, looked very much like my dissent. He reasoned that any air pollutant, that's the statutory standard, any air pollutant means any air pollutant. Greenhouse gases clearly qualify as a pollutant. Greenhouse gases clearly qualify as a pollutant. Clearly classify as a pollutant. As Justice Stevens acknowledged, EPA can exercise its judgment in setting an appropriate standard for greenhouse gases, but what it can't do is set standards on basis of factors that ignore the congressional mandate. In the words of the statute, reasonably be anticipated to affect the public welfare. I was pleased that Justice Stevens quoted my dissent throughout his opinion. Indeed, he called me that afternoon to thank me for writing it. I'd give him a roadmap, he said, for deciding the case and retaining his fragile majority. In American Trucking and Mass v. EPA, the Supreme Court modeled judicial restraint. It respected Congress's judgment, applied statutory text as written, and ultimately let EPA experts make the necessary scientific judgment. Today's Supreme Court, however, is increasingly unrestrained, preferring to make its own calls on difficult policy questions involving environmental issues and beyond. That's not how courts are supposed to operate. An egregious example is a case called West Virginia against EPA, which involved a regulation known as the Clean Power Plan. Adopted in 2015, the Clean Power Plan was the Obama administration's major effort to fight climate change. It was designed to reduce emissions of carbon dioxide, the greenhouse gas that accumulates in the atmosphere and affects climate, by shifting the nation's power grid away from carbon dioxide emitting sources like coal and towards natural gas and wind, and before non-emitting, like natural gas and wind. Yes, the shift would be costly, but EPA is required by the Clean Air Act to reduce carbon dioxide emissions to safe levels, including by requiring power plants to use, now this is the key language here, to use the best, quote, systems of emission reduction. And after much consideration, EPA scientists determined that shifting power sources was the best system for reducing greenhouse gases. Clean Power Plan was challenged almost immediately, but before the regulation took effect, political winds shifted, Donald Trump was elected, and his EPA repealed the Clean Power Plan. According to Trump's EPA, Obama's EPA had exceeded its authority by issuing the Clean Power Plan, because questions about whether and how the nation should move towards cleaner sources are too big, too major for a mere agency to resolve. In place of the Clean Power Plan, Trump's EPA issued a new regulation, branding its version the Affordable Clean Energy Rule. Affordable it was, clean it wasn't. Trump's rule required coal-fired power plants to make modest improvements, but gone was any requirement that they shift towards renewable energy sources. EPA's change of course led my court to dismiss the case without issuing an opinion. The Clean Power Plan had been repealed, so there was nothing left for us to decide. Or so we thought. As it turned out, the saga was far from over. President Biden was elected. The Trump plan never went into effect, and Biden's EPA began working on a new regulation. So there was little left to fight over. A restrained Supreme Court, one that abided by the principle that, in Chief Justice Roberts' words, quote, if it is not necessary to decide more to dispose of a case than it's necessary not to decide, would have let sleeping dogs lie. That isn't what happened. Writing for a 6-justice majority, the Chief Justice ruled that Obama's EPA lacked authority to issue the Clean Power Plan and Trump's EPA was right to repeal it because questions about power sources were too major for a mere agency to answer without express authority from Congress. If that reasoning sounds familiar, it should, because the major questions doctrine is a close cousin of the non-delegation doctrine that Justice Scalia shot down in American Trucking. Both doctrines reflect a fundamental distrust of agency action, and neither doctrine has any basis in constitutional text. Although both doctrines purport to prioritize Congress's authority, they ultimately empower the courts, which can use the two doctrines to override any congressional delegation they don't like. And both doctrines have long been darlings of the conservative legal movement, intent on stripping back federal regulation. Non-delegation is the bigger fish, as it would prevent Congress from delegating important decisions to agencies, no matter how clearly Congress speaks. Major questions, though, is a good consolation prize, as it allows for such delegation only if Congress speaks with unmistakable clarity. But the regulatory agenda reflected in the non-delegation doctrine and major questions doctrines has implications for everything, everything from broadband internet to healthcare and to workplace safety. It's particularly troubling when it comes to the environment. Environmental issues almost always implicate big technical problems that demand big technical solutions, as Congress recognized when it passed the Clean Air Act. Expert agencies are best situated to craft those solutions. Also, I have no idea how courts are supposed to decide in a principled fashion whether a particular issue is too major for an agency to decide. I suppose they'll just have to guess whether 5 justices would object to the agency's rule. But what I do know is that by affording itself a roving mandate to disrupt any regulatory scheme that strikes 5 justices as too major, the Supreme Court strengthened its own hand at Congress's expense. Doing so in the name of separation of powers and supposedly out of concern for Congress's constitutional prerogatives makes that move all the more dangerous. And here's the kicker. Under the major questions doctrine, the more important the regulatory issue, the likelier that generalist judges, rather than scientific experts, will make the final call. Doesn't that sound exactly backwards to you? Just a few days before the West Virginia decision, the Chief Justice had cautioned against decisions that, quote, jolt the legal system. West Virginia was an earthquake, and only time will tell where it falls on the Richter scale. I'd like to end this talk on a hopeful note, though I'm not sure I have much to say that's hopeful about the environment and this Supreme Court. Major questions is now the law of the land, leaving agencies without authority to answer any questions 5 justices consider major. Even more troubling, as I write this chapter, Chevron, the basic notion of interpretive deference to agencies, is now on the chopping block and likely to be overturned this June. And worst of all, a majority of the sitting justices, I'll let you guess which ones, have expressed an interest in resuscitating the New Deal era non-delegation doctrine that Justice Scalia rejected in American Trucking. The justices apparently fear that without these new mechanisms for judicial intervention, agencies will run amok. That fear is totally unfounded. For decades, the constraints baked into the Constitution, the Administrative Procedures Act, and other congressional statutes have effectively constrained federal agencies. Agency heads are appointed by the president and confirmed by the Senate, and the president can fire them at any time for any reason. Meantime, Congress decides how much authority to delegate to federal agencies in the first place, oversees their work, can repeal any regulation with which it disagrees, and can even withdraw a delegation altogether or disband an agency altogether. The courts, for their part, hear challenges not only to agency action, but also to their failures to act. When a regulation or a failure to regulate runs afoul of the Constitution or a statute, or is otherwise arbitrary and capricious, courts vacate the agency's decision and send it back for a redo. But stripping Congress of its power to delegate to agencies in the first place, or stripping agencies of their power to answer major questions and interpret ambiguous statutes, is something else altogether. Our system of government cannot function without agencies and the scientists and civil servants who work for them. As the world keeps getting more complex, we need expert agencies more than ever. Anyone concerned about the environment, or with safe medicines, unadulterated food, or cars that drive safely, has very good reason to worry about where this Supreme Court is headed. Supporters of the major questions doctrine respond by saying, well, all Congress has to do to empower agencies to answer major questions is to say so clearly. That, after all, is the theoretical difference between non-delegation and major questions. Non-delegation prohibits Congress from empowering agencies. Major questions requires only that Congress make a clear statement to that effect. But it's really not that simple. As major question supporters well know, Congress often struggles to pass any legislation at all. And when it does pass an important law, it often chooses to delegate to agencies the power to solve complex social problems. Congress didn't tell the EPA to use the best system of emission reduction, including shifts to new power sources, because it just wasn't yet clear that a power source shift might prove the best way to reduce carbon dioxide emissions. Congress wanted experts at EPA to make that decision. Moreover, even if Congress had somehow foreseen that major question coming down the pike and spoken clearly enough to satisfy the court, non-delegation is still lurking in the wings, a tool for empowering the courts to strike down significant regulations, no matter how clearly Congress speaks. With this Supreme Court, I fear it's only a matter of time before it breaks the glass and grabs that tool too. Thank you.
The first time I ever encountered this issue broadly was when the conservative firebrand Steve Bannon started talking about the deconstruction of the administrative state.
Right.
I don't know if it was before Trump was elected or after, but it was back in that 2016 period. And the question I have for you is just, I think, a fairly simple one, which is it strictly about the resentment of some corporations at the restraints that are put on them, or is there some philosophical, constitutional theory about why we should not have these agencies that do so much work for us?
I think, Dan, it's much broader than corporate interests. Certainly, corporate interests opposed to regulation are a big part of it. But this movement is driven largely by a decades-old conservative movement seeking to limit the power of the federal government. That's what this is really all about. And its biggest concern is that regulatory agencies have too much independence, that they view them as not sufficiently accountable to the president and to Congress. And that's what's motivating. It's a battle about government, it's philosophical, and it's actually very, very fundamental.
And in the course of dealing with this issue over many years, have you ever posed the question to someone, can you imagine the world without an advocate of these positions. Can you imagine the world without the EPA, without all these different agencies that we rely on? I mean,
Well, I mean, I have had those conversations from time to time with my colleagues who believe in these doctrines, and their answer is, well, Congress just has to make these decisions. That's the way our system of government is set up. Congress is elected by the people, and it should make the decisions. And they don't have any patience with the natural response, which is, well, Congress is dysfunctional. But that's satisfactory to them because preventing Congress from delegating authority, if the Congress is dysfunctional, produces the result they want, which is no regulation at all.
So I'm reminded of somewhat off-color story told to me by a mutual friend of ours, late friend, Sandy Berger, who during his time, before he was National Security Advisor, his Deputy National Security Advisor, he was up on Capitol Hill, and he was talking about the war in Bosnia, and he came back, and he was, as you know him well, he was an energetic and fairly ebullient guy, and he was a little downcast. And he said, "Have you been up there recently? Turnips. I've been talking to turnips." And it was hugely dispiriting. You know, one congressman he'd been talking to, he briefed him for 2 hours, and then the guy said at the end, "Everything we've been talking about, is that in the former Yugoslavia?" So the idea of turning these things back to Congress is rather preposterous. I guess I would ask the further question, have you had any interactions with Congress itself on this issue? I mean, I know
No.
Congress would not appear in your court, but...
No, but that's a really good question, Dan, because if there were a real problem with administrative agencies out of control, let's say there is one. But let me go back. I served on this court for 30 years. I heard hundreds of cases from agencies. And I saw our system working the way it's supposed to work, with the judicial review and the other procedures we have, confining agencies properly. I don't know of any examples of agencies abusing their power and not being reversed by the courts or held accountable in some other way. And none of the members of the court who have adopted these views have identified any either. But let's assume there was a problem. The way we solve a problem like that in our government is Congress is the one that created the agencies. If Congress thinks there's a problem with administrative agencies, it can hold hearings, have witnesses come in and talk about what's happening in the real world, and fashion legislation to correct it. They've already done that several times. They passed quite a few years ago the Congressional Review Act, which allows two houses of Congress to revoke any regulation within a specified amount of time. In other words, Congress can act to control these agencies. If Congress really thought there was a problem with agencies acting in where there are major questions, it could have amended the Administrative Procedures Act. But that hasn't happened. Now what we have is the Supreme Court doing what Congress should have done. That's not the proper role of the Supreme Court.
So one of the interesting things that we've really seen in full force since the COVID pandemic is the rise of a kind of anti-scientism,
right,
that has had a profound effect on public life, not only in America, but all over the West. And it seems as though that has kind of turbocharged the crusade against the administrative state. Has that shown up itself in the cases you saw, or is it purely atmospheric, or do you think that this is something that the interests that oppose these, the administrative state, are just riding in a kind of, parasitic way?
I think even among judges and justices, there's a growing skepticism about science, about all experts. You can see it, you can hear it in the questions that judges and justices ask at oral argument, and you can see it in their decisions where they ignore the scientific findings of agencies. They're skeptical about it. In my conversations on the court, you can detect great skepticism about the science underlying climate change. But as long as the courts are deferring to agencies' reasonable fact-finding, which is what we've been doing up till now, those disagreements don't get surfaced in decisions. I had a case quite a few years ago, one of the major environmental clean power cases involving the first set of carbon dioxide emissions. I was sitting with two judges who were both were appointed by Republican presidents and both quite skeptical about the agency's scientific findings. But we issued a unanimous decision because even as they looked at what the agency had done, it had considered the relevant evidence, it had considered the opposing issues and reached a rational decision. So the arbitrary and capricious standard, the deference standard, covers up these disagreements between judges. But once the courts are making the decisions, like the Supreme Court is insisting on in the major questions case, then those divisions will surface in opinions, and you'll have courts divided not just on the basis of their view of law, but on their basis of their view of the underlying science.
So I want to, first of all, move a little bit to your personal experiences, because we just saw you struggling with the technology.
Yeah.
One of the things that amazed me in your book was how many different technologies you've mastered over the years. If we were doing this 30 years ago, you wouldn't have any technology to really rely on, would you? Maybe you want to give the audience just a quick overview of how you had to migrate from one technological universe to another.
It helps that I really actually like technology most of the time. Like, not so much tonight, but most of the time. I mean, all right, so here's a really good fact that shows you how the world has changed. When I first went on the D.C. Circuit in 1994, in addition to my 4 law clerks and secretary, I had a full-time reader, a college graduate who worked for me for a year as a reader, plus a 1/3 time backup reader. So I had 1 1/3 people during the year reading for me. And that's all they did. They read briefs, they read correspondence, they read everything to me. Everything that I needed to read. And I guarantee that's a lot on a court like the D.C. Circuit, where you have massive records and lots of materials to read. Today, I have just 1 reader, no backup reader, and that reader spends 5% of her time reading to me.
Wow.
And that's because of technology. In those 20 years, starting maybe 30 years ago, the technology has moved to the point where almost everything is now digital, and I can read almost everything with various devices. The iPhone being one of them until tonight. So technology has had a dramatic effect on the ability of blind people to function. It's quite remarkable.
So I have to ask, did you ever have a reader whose voice you just couldn't stand?
Yes, absolutely. Yeah, I have. And some of the technology has really awful voices. But you get used to it after a while. You could not, I guarantee no one in this room could listen to the way in which the sources from where I get some of my books. It's a not very well developed computer voice. But the fact is, if you listen to it for a while, you get used to it. It's fine. Yeah.
So back to a legal question, which if I don't ask it, someone in the audience certainly will. One of the things that I think puzzles non-Americans most is the doctrine that I'm sure you come up against all the time, or didn't when you were on the bench, of originalism.
Oh, yeah.
And I was wondering if you could give us your thoughts on originalism, because to at least, this contemporary mind sitting in Europe in 2024, it's hard to find a genuine intellectual justification for it or defense for it. The notion that we just figure out what people thought in 1789 or 1793, and that is what should fully guide us in dealing with the decisions of 2024. I'm guessing I'm knocking a little bit on an open door, but I'm eager to hear what your thoughts are on this.
Well, yeah, you are kicking open an open door. But, the fact is, all judges are, in essence, originalists. That's right. We're all interpreting the Constitution. The question is, what tools do you use to interpret the Constitution? The current movement for originalism, the strictest form of it, which you've seen on this court, has an extremely strict view of what it means to interpret the Constitution, based just on evidence about what the framers meant at that particular time. Others consider interpreting the Constitution more broadly. My own view is that this is a huge debate in academia. I guarantee you it is not an issue that sitting judges sit around and talk about. We have a case, my court, we have fewer constitutional cases in the Supreme Court, but we do have them. But when we do, we aren't sitting around debating whether we're originalists or not. We're all trying to figure out what the constitutional provision means in that particular case. My own view is that originalism is a device that has been adopted because it produces results that the originalists want. That's where I am. I don't think it's any more complicated than that. And here's a really interesting story. You've all read about the latest decision by the Supreme Court involving whether former President Trump can run this November, right? Well, you know the story. Two very highly respected originalist law professors wrote a very long and very persuasive article using originalist techniques, concluding it was absolutely clear that he could not run. So one would think, okay, this originalist Supreme Court would kick him off the ballot, right? Well, these 6 originalists didn't do that. So it's just an example of how originalism is useful when it produces the results they want, and not so, and abandoned and not discussed when it doesn't produce the result they want.
Okay, well, you brought up the issue of the former guy, and so I have to ask you, if you were going to handicap the outcome of the immunity case, what do you think we're going to hear?
Now that I'm retired, I can answer questions like that. Look, I think the case is frivolous. I think it's frivolous. I thought so from the beginning. I thought my court's decision was thorough and got it just right. But the Supreme Court is Supreme Court. And I would be extremely surprised if the Supreme Court concludes he can't be prosecuted. But I'm not the best person to predict things like that, Dan, because I also predicted it wouldn't take the case, and I was 100% wrong about that. But I will be very surprised if they take the case. I mean, there might be a dissent, but I cannot believe that, having looked at the case pretty carefully myself and read the briefs and the D.C. Circuit's fine opinion, I just don't see it. So.
Okay, well, questions. We have a lot of attorneys in the audience, and so I feel like it is time for me to hand over the microphone. Sure. Well, we're going to go first to a philosopher, and then we'll go to the attorney. So watch out.
Yeah. Okay, awesome. Thanks. I'm David Plunkett. I'm a philosopher at Dartmouth College. So thanks so much for your talk. It was really interesting. I guess one of the things I was wondering about, with your discussion of like the major questions doctrine and the anti-delegation stuff, there's both a question you were saying, it seems like it's bad law, like they're misunderstanding what the law in fact is in the United States. But you also have this policy view that it's like it'd be a problem to have the major questions doctrine because of this function of Congress. We wouldn't get stuff done on some of the most pressing problems of our age. So climate change being an example of that.
Right.
I guess I wanted to separate out the legal question from the policy question for a second, and just wanted to hear your thoughts on like a major questions doctrine if Congress wasn't dysfunctional. So I'm super sympathetic to where your political views are given the actual Congress we have, but I wonder how much of that's contingent on like the deeper problems we have in like a dysfunctional Congress reflecting a dysfunctional democracy. And so I'm just curious about how deep your commitment to opposition to the major question doctrine goes and how contingent it is based on your analysis of current politics.
Well, it's largely, we're setting aside the legal issue now, right? I mean, we're not talking about that. I mean, from my perspective, it's congressional dysfunction that makes the major question doctrine so dangerous. Because it is the law of the land now, and by late June, Chevron will be gone. And that will mean that all courts, my former court, the Supreme Court, will be deciding all of these administrative law cases based on their own interpretation of the law. And that means two things. It means, number one, they'll be ruling that agencies can't regulate. There'll be a long series of decisions rejecting agency regulation. We're going to see some of them in June. And then there'll be no congressional response because Congress is unable to act, which means that these areas of our society that need standards, need regulation, just won't have it. So in addition to thinking there's no constitutional basis for these, I also think it's very unwise policy. I mean, our system has worked. The administrative law system we have has worked under the Administrative Procedures Act since the late 1940s. It's not a problem. Unless you don't like the results that agencies are reaching, then it's a problem. I don't know if I answered your question.
Now, Professor Grimm.
There's no equivalent term to the administrative state in German law. We have a growing administration, but we don't have the administrative state. In Germany, the reaction to the liberal state was the welfare state. Mm-hmm. But the welfare state is something different from the American administrative state. And I think one of the basic differences is the existence of independent agencies in the United States, and this is alien to German law. We have a few ones now via European law, but in German law, this is an import from another legal system. So the German system basically doesn't know them. Every unit of the administration has to be under the control of a minister. And in the ministerial administration, the expert knowledge is accumulated. The minister is accountable to Parliament, and Parliament is accountable to the general public, the electorate. And this is what is called in Germany the chain of democratic legitimation. And so my question is, how do you reconcile in the United States, not you personally, but the United States general attitude, how do you reconcile the existence of the independent administrative regulatory agencies with the principle of democracy?
Well, the administrative agencies are operating pursuant to statutes passed by Congress, the most democratic of the three branches of government. They get their authority from Congress. They have no authority that Congress doesn't give them. So it's a completely democratic system. There's nothing anti-democratic about it at all. These agencies have only the authority that the Congress gives them. And if they abuse their authority, the courts overrule what they do. It's completely democratic.
Professor Ziblatt.
So following up very much on the last question, I'm a political scientist, so I don't know much about the non-delegation doctrine. But it sounds as if the non-delegation doctrine is the issue is not that authority hasn't been granted to administrate, it's a misinterpretation. I mean, is that essentially that the EPA has had authority delegated to it to act independently and autonomously? And I mean, so that's not, so that, what's the problem exactly with the non-delegation doctrine, given
Well,
the last question?
okay, so the non-delegation doctrine says, let's take the particulate matter example. Under the non-delegation doctrine, Congress probably could not delegate to EPA the authority to regulate particulate matter. Congress would have to build the regulation into legislation that it passes. So if Congress thought that PM10 standards weren't adequate, it would have to have hearings, hear witnesses, and pass legislation setting a PM 2.5 standard. That's the way it would work under the non-delegation doctrine. Can you imagine that happening in the United States? Let me quibble with two words you used. You used the word autonomous. That's not the way administrative agencies work. They aren't autonomous. As I said in response to the question right before yours, they have only the authority that Congress has given them. I can point to dozens of Supreme Court decisions and lower federal courts decisions, many of which I've written, which make just that point. An agency has no authority. In fact, I had a case a few years ago involving the regulation of the internet, where the FCC was arguing that it had authority to impose basically common carrier requirements on internet providers because of their, quote, inherent authority under the Communications Act. I ruled in my opinion, agencies don't have inherent authority. The only authority they have is the authority that comes from Congress. They have to find it in the statute. And if it isn't there, they can't act. It's a completely democratic process.
Right here. Can you wait for the microphone? Yeah, thanks.
I was wondering if you could talk just a little bit about the process of judging and being a generalist and educating yourself. You're coming up against the EPA with all of its experts on particle sizes.
Right.
Now judges have to be experts on herring this year. What is it to try and make sense of all of this so quickly when you're up against this administrative state with all of its experts and you have to understand what they're doing and maybe second guess what they're doing?
Well, again, I want to quibble with your question just a little bit. First of all, you are absolutely right. And that's what made my job so deeply interesting. Yeah, these are really complicated cases. The Massachusetts v. EPA, the greenhouse gas case, the administrative record, that's the briefs and everything else, was filled, this is in the old days when we had paper, filled 3 full file cabinets. There were hundreds of scientific reports in the record. But our job was not to decide whether carbon dioxide harmed human health. That wasn't our decision. Our decision was focused on, did the agency evaluate the evidence, make a rational conclusion about it? So I did have to understand the science, but I didn't have to make the decision. All I had to do was make sure the scientific process had been followed. And my quibble is with your use of the word second guess. That's
what say understand what the agency is doing rather than second guess.
Yes.
Try and substitute.
No. Yes, we don't do that. But that's right. Second guessing is not what we do. But once this Supreme Court is through, you will find judges second guessing what agencies do. You'll find these decisions made by the courts, not by Congress. But digging into these cases is one of the most interesting things about the job. And I think another issue that's lurking in your question is that in the United States, the federal courts are comprised of generalist judges. We're not environmentalists. We're not financial experts. We're generalists. And the idea behind the system is that it works best when generalist judges are educated by the parties. So the briefs they file are critical because the job of the lawyer is to make sure the judges understand the science sufficiently to be able to apply the arbitrary and capricious standard to what they see. So,
I do want to hear afterwards about the Herring case. I just want to point that out. Okay, it's right here. Sebastian.
Hi, thank you. Sebastian Siedorf. I work for the German federal administration, so thank you for your praise of the democratic administration, if not for the administrative state. Now, I would like to invite you to a thought experiment of a kind. Now, let's imagine that with a majority in Congress, one of these agencies gets abolished altogether. It's maybe a policy issue of a new administration. Then it's, if I'm not mistaken, it would be then left to individual litigants to claim that some environmental hazard infringes on their right to health, basically. But could you imagine that there is a minimum standard for administrative regulation? Is there a low water mark where there's a constitutional duty on Congress to make sure somehow that there is administration administered? Or is it possible to abolish all these agencies one after another?
Yes, I think Congress could abolish the EPA if it wanted to. It would amend the Clean Air Act and abolish the Environmental Protection Agency, and that would be the end of the matter. Now, that means that, litigation would, it's hard to imagine what would be left, but there might be there might be emissions litigations about pollutant litigation in state courts. You could have that. Or maybe there are other federal laws under which people could sue, but Congress can abolish these agencies completely. I can't think of an agency Congress can't abolish. It can abolish, it can't abolish the Supreme Court. It's in the Constitution. But I can't actually think.
What about the ones that are enumerated in the Constitution, like state?
Like states?
Yeah. No, the State Department.
Oh, yes. It doesn't. Well, it says Congress can create these agencies, right? It doesn't say Congress has to.
Well, it was bold of them to do so.
Could it abolish the State Department? That's an interesting question. It created it. I mean, it passed a law.
Don't say it too loudly.
Creating the State Department.
Nervous,
It authorizes the creation of these departments. I think it could clearly decide we don't need a State Department.
All right,
the interesting question is what would happen if the president decided not to appoint a Secretary of State because he didn't like the State Department.
That day may be coming.
Yeah.
Okay. Mark, is that you over in the corner? Yeah.
Hi, thank you, Judge Tatel. I'm Mark Massoud, one of the fellows this semester at the American Academy. So you gave this really sweeping distinction between administrative policymaking or bureaucratic agency policymaking and this rise of judicial policymaking where judges are making the policy rather than administrative agencies.
Yeah.
And I kept thinking back as you were talking, not to the environmental examples you gave, but to prison reform. It was judges who, when prisons could not reform, judges were appointing special masters. Judges were the ones who were reforming America's prisons at the time. You know, the largest kind of prison reform project in American history was through the courts.
Yeah.
So part of me was saying, maybe there's not so much that's wrong with judicial policymaking in certain areas. Maybe in the environment it is, but maybe not so much in prisons. So I wonder if you can help me understand when judicial policymaking works and when it doesn't work.
Well,
and then my other question is, if it is so bad, is one of the solutions term limits for judges? I know a lot of people have been talking about 18-year term limits for federal judges.
All right, well, let me take those one at a time. So with the prison reform, the prison cases, the reason the judges, whether you think they got it right or wrong, the judges only were acting because they had found a constitutional violation. In other words, they found that the prisoner's constitutional rights had been violated. And they had to fashion a remedy for that constitutional violation. That's what the prison cases are about. Same thing with school desegregation cases. The only reason the courts are fashioning school desegregation plans or prison reform plans is because there's an underlying constitutional violation. Now, then we ask the question, well, okay, were the judges effective as policymakers? Well, some were, some weren't. Some prison reform has been successful, but in large respects it hasn't. Same thing with school desegregation. But that's a completely different kettle of fish there. That's judicial, you might call it policy making, driven by the need to provide a remedy for a constitutional violation. Okay, term limits. I have been, when President Biden got elected, he created a commission to examine the courts. And that commission, their report's really interesting, and it considers many different solutions, like, expanding the size of the court. He created this because there was huge pressure from within the Democratic Party to add justices to the Supreme Court. So instead, he creates this commission. And one of its recommendations was term limits. And the term limit idea has been floating around for, and I don't mean floating to be disparaging of it. I actually think it's pretty interesting. Has been around, I think, since the early part of the century. The idea being that, particularly for the Supreme Court, justices should serve for a specific number of years. And I've been opposed. I was opposed to that for years. I try to explain in my book that I now think term limits are a good idea. But this is an abstract discussion. It isn't going to happen, or it can't happen. The first question is, can Congress constitutionally impose? Remember, the Constitution says judges, Supreme Court justices, and judges like me, we serve for, quote, good behavior. That's the language in the Constitution. And that means for life, unless you get impeached. And so many people think that Congress can't impose term limits on judges and justices. There are just as many highly thought of professors and writers who think it could, but then the question is, would this court declare it unconstitutional? We don't know that. But there's an antecedent question there, which is there's no way that this Congress is going to pass term limits. It's not going to happen, right? There's a filibuster. I mean, I don't even think you could get a majority in this Congress, much less any other Congress, for term limits. It's just Congress isn't going to do that. So it's an interesting abstract discussion to have, in law schools, but it isn't going to happen.
So I'm going to abuse the privilege of the last question as well as the first, and talk a little bit about your book.
Oh, thank you.
As a way of floating, for use of for want of a better verb, in front of our audience, some of the really interesting themes in it, and one that is woven throughout the book, and you're not going to be able to give the whole story here, but that is woven throughout the book, is the challenges you faced in coming to grips with your own blindness, right. And that the time it took to accept and overcome it as opposed to try to hide it, I guess.
Yeah.
And I was just wondering if you'd want to talk about that for a moment, because I think it's one of the really compelling themes within the book.
Well, of course, that's one of the reasons I wrote the book. It took me, 90,000 words. I hope it didn't take 90,000 words to explain it, but my effort in the book was to try to deal with that. For those of you, I hope you read my book. Nobody here's read it. So I have an inherited eye disease called retinitis pigmentosa. It's genetic. And the progression of the disease is that when you're, at least my form of it, is that you you begin to lose various forms of sight as you get older. Mine was pretty typical. You first lose night vision. I can never see at night. Then you begin to lose peripheral vision. And by my mid-30s, I had pretty much lost any ability to read or maneuver on my own. When I was young, I try to explain this in the book. I mean, kids, you want to be like your friends, right? I struggled with this disability. We didn't call it that then. I didn't talk about it. I covered it up as much as I could. When you read my book, you'll see I had lots of very creative ways of doing it. Many of them were actually pretty effective. But I think it's, as I look back on that, I mean, that teenage boy, that 20-year-old, that was a very long time ago. It was me, but, I've tried to do the best in the book to explain why I did what I did. And I think I felt like many people that having a visible disability that it was A, embarrassing, and B, that it would limit my professional opportunities. It soon reached the point where it was inevitable. I couldn't avoid it anymore. And I talk in the book about, first beginning to learn Braille, and then the difficulty of finally stepping up to the plate and using a white cane. That was a very big step. And then ultimately getting a guide dog, and I wish my dog were here. There's a whole chapter in the book, last chapter, called The Dog That Changed My Life. Those of you who like dogs will love the chapter, I think. So I tried to tease this out. And here's, at least to me, Dan, the really interesting thing about it. And the person who knows this better than anybody on the planet is right there, my wife. Because, Edie, when we were dating, Edie knew I had this problem. And the two of us have lived with this throughout our very long marriage. And I've gotten better at dealing with it. But the really interesting thing to me is that writing this book was part of the process. Writing the book forced me. I didn't want to write this book at the beginning. And if you when you get the book, read the epilogue, and it explains why. If we had time and if I had the technology, I'd read it to you now, but I don't. And I explained there why I wrote the book. The book, I have made more progress in the 2.5 years Edie and I have been working on this book than I did in the previous decades or so. Because people who I care about deeply, my wife, for one, a couple of close friends, my editor at Little Brown, my agent, asked me very hard questions and said, basically, no one's going to read your book unless you're prepared to answer these questions. And so I've tried my best. I've explained it. Readers will have to reach their own judgment about what was motivating that young David Tatel and whether what he did was right or wrong. But I've tried in the book to lay out what I did and why and how I struggled with it. And this book is the coda to all of that. It really is. I am far more comfortable with the blindness. Give me an example. If I had done that speech 5 years ago, and the technology had failed, I probably would have sat down. So, I had the confidence, to be able to work my way through it. I'm sorry it happened. It's not the first time, by the way. It happened once. The last time it happened was in a memorial speech I was giving, and that was really kind of tricky. But, so that's the story, and in a way, that's one of the many themes in this book, which is, why, how, and what happened in the end. So I hope you all read it.
I certainly hope you all read it. I will tell you that the thing that amazed me most, it is interesting throughout, but what was amazing to me was the upbeatness of the entire thing and how distinctive and optimistic the voice is in it. And it was certainly not what I would have expected opening up that book. And so anyway, congratulations.
Thank you, Dan. That's very nice of you.
The Academy would buy you all copies, but we can't, so you have to buy it.